compliance practice, key priorities, risks, and the road to readiness. CII, along with Protiviti, brings to you this webinar, which is very, very timely. Of course, the rules were out last month, but then there have been a lot of discussion around it and, how companies, organizations need to move. So I'll just quickly just mention about what CII Digital does. I'm Kavita Nair. I'm with the CII Digital team, and I look after the IT, ITS, telecom, and AI. We do a lot of policy advocacy and outreach. And CI Digital believes in creating awareness on all important aspects that would impact industry. This is one of those initiatives where we have brought to you this webinar. We have with us Dr. Gulshan Rai, and we are very, very honored to have his presence here because of his rich experience, having led CERT-In also, and he continues to lead a lot of cybersecurity activities in the country. And welcome to you, sir. We have Mr. Vaibhav Kaul, who's leading cybersecurity related areas in Protiviti, and has been a partner with us for a survey we did on DPDP in 2023, trying to understand the readiness of industry where DPDP is concerned. And that has really, really helped create a lot of awareness around the subject. Industry knows that this is going to come anytime. And we have been able to create awareness through that survey as well. We also have with us Kirti, and Kirti is going to talk about some of the techno-legal aspects from Shardul Amarchand. We've been working closely with them as well on DPDP when we used to have discussions around it with our members. And it'll be wonderful to hear each one of you speak about this very, very important area. With that, I would like to invite Vaibhav Kaul to kindly set the tone and the context. Over to you, Vaibhav.
Thank you so much, Kavita, and really a pleasure to be here. I'll just quickly share my screen. All right. So, as we all are aware, this has been a particular act and the related rules which have been in discussion since the last quite a few years. Right, so 2017 was the year when the right to privacy was formally provided to Indian citizens as part of the Puttaswamy judgment. And then August 23 is when the DPDP Act actually fully came into acceptance. Now, early Jan 2025, the draft rules were kind of released. And we recently have the finalized rules come in November. Now, as part of the requirements, the overall implementation or the operationalization of all the rules for organizations, a timeline of around 18 months has been provided. And in this session, the intention is that we'll talk about the various aspects, starting from maybe some details on the current readiness, like Kavita mentioned, in terms of the surveys that we have done in the past, but also taking it ahead to look at the governance and the operational aspects of the Act at an overall level, where Dr. Rai will guide us. Then looking at the techno-legal aspects of things, where Kirti will support us on that. And then we'll talk on focused measures related to the practical implementation of the Act. So be it on the process side, be it on the technology side, be it on the people side, what needs to be looked upon there. So what you see on the screen are some highlights of the survey results that were done along with CII. So what we had noticed was around 60% of all the organizations that were surveyed, they felt that practices which were unsafe from a privacy perspective, they were being followed within organizations. Around 52% of the organizations felt that in the last 5 years, there was some or the other sort of a privacy breach that had occurred. A good chunk of mature, large organizations had set up their privacy offices, but majority of the organizations were still relying on multiple teams, and a dedicated unit was not there. Like the ITIS teams were being looked upon, the CISO teams were being looked upon, certain cases legal teams, and certain cases certain business functions were kind of handling it, right? And apart from that, what we noticed earlier was in terms of the overall implementation, it was just around 11% of the organizations that had gone ahead and started the privacy program implementation. And this is around a year back that we are talking about, right? So the intention is to kind of take it ahead and understand how things will go in this year, considering the complete operationalization as well. So during this webinar, we'll also consistently have some polls set up, and it would be great to get your inputs during the poll as well. With this, I'll like to pass it on to Dr. Rai to take it ahead and talk about the operational aspects as well.
Thank you so much. In fact, it was good that you talked about the journey that we've had, Weber, so that it's not something that industry doesn't know about. They've been looking at the various ways of getting ready for this. Now, I would like to invite Dr. Gulshan Rai, our former National Cybersecurity Coordinator, PMO, and Director, the first Director General of CERT-In. With his vast knowledge and experience, he will guide us much more than what the rules are telling us today. Thank you, sir. Over to you.
Thank you very much, Ms. Manan. I'm so grateful to CII and particularly to you for inviting me, giving me the honor, and facilitating me interaction with whole lot of people. As I was telling our friend Kirti that whenever we meet, we try to, it's a two-way exchange process and we try to learn from each other. I may be knowing so many things, participant may so many things, but when you interact, new issue comes up, which makes you a little more enlightened and think what all is happening there. Friends, you have heard what Mr. Weber Call has introduced, how the journey of the Privacy Act comes up. Many of you would have this kind of a thinking. After all, why do we require a privacy law? Why so privacy is important, and particularly more in Indian environment where our neighbors knows everything about us rather than I might knowing anything about it. Before I reach home, my neighbor will be knowing about me rather than I will come to know more about it afterwards. That's a kind of state of privacy is there. Our culture is there in India. Friends, the Indian, if you look at the entire economy of the world, is more than $110 trillion. Out of $110 trillion, 49 to 50% is digital economy. That today anything and everything moves through the digital means there. That's why first called techno world. If you talk about the legal, it's a techno legal. If you call it a privacy, techno privacy. If you call anything is a techno word comes up because technology is embedded and it's a technology component, maybe small, but actually it drives and optimizes the efficiency and productivity of any system. You transfer any money within India or outside, it's largely through the online means. Online means will get involved. I may go to the bank. I will say I present a check, he gives me money, whatever money I want, he can give me to me. But actual transactions are through the online system. I go and book an airline ticket, or I go and book the share market, capital market, anything you do. The online system, electronic systems are involved over there. If you look at the UPI, I have to use my mobile phone or kind of a laptop which provides that UPI interface to me. It's online. I do from mobile phone, it goes to the telecom service provider. Telecom service provider, it goes to my bank. My bank again sends back to the NPCI. NPCI, it goes back to the, again come back to telecom service provider. NPCI, again and telecom service provider. And again, the bank from where the money is to be debited or credited and then returned back. You can see how many players are there. This is one example. I pose it before you. I gave it before you. Similar thing you do for the railway reservation. You do for the air ticket reservation there. Same example comes up. Means that anything and everything you do is separate digital online transaction. And as I gave you example to all of you, in an online transaction, so many stakeholders, so many players are there. I give example of UPI, my phone, service provider, my bank, NPCI, telecom service provider, and then again the bank there and return part. Look at it. None of them has a control on any of the data transaction which comes up there. Everyone has his own policy, everyone has his own customs, and they do the business, conduct the business as per their own procedures and rules. So who will be, that means data is collected at every place. Data can be leaked at every place there. A simple, another example I gave you, most of us get a I recall, I'm calling from bank manager and so something is happening and all kind of a thing. At times you will be wondering who is leaked out our data. Numbers are leaked out because you give the number of data. If you go to any seminar organized by Protiviti or CII, now CII doesn't do the, Protiviti doesn't do that. What they used to do, they will say drop your visiting card. That visiting card will be picked up and the later lot of data will be collected. And I don't want to name, so many e-commerce service providers were using that technique to pick up the phone and calling you there. And that becomes a source of cybercrime. So you can look at in a digital, when you're talking digital transactions, the transaction gets complete after passing through so many stakeholders, so many points there, and everywhere data is collected and data is transferred. Whenever the data is transferred, it has to be collected, then sent to another device, and then go to another device. That's how the digital technology works up there. So if the data is leaked out, you don't know where data is leaked out there. Data becomes at times it becomes a very, very difficult data. So I give you another horrible example. Somebody knows I am allergic to some perfume or something like that. He or she knows it. I get to the lift. He or she knows that I go to this building, and so and so time and go to the so and so floor there. Before I enter the lift, they put some kind of a perfume there, which is I'm very allergic to that perfume there. And if I go to, let us say, 10th floor, by the time the lift reaches the 10th floor, I'm dead. That kind of scenario also you can see. Data is given to everywhere, hospitals there. If the leaks out, what havoc will get created in a digital world. That was not so when the print data was there. Print data was there only between you and your service provider. It was not in public. But digital data, as explained, it is everywhere without any control, without anybody's thing. So the privacy of the digital data, because of its obvious, that's not a new, all of you know, privacy of the digital data has become an important factor, and the Privacy Act is an essence part of it there. Is a essence part of it. Many countries have implemented the privacy because of this factor there. We have also passed the law in August 2023, the Privacy Act, so-called DPDP, Data Privacy Protection Act. We passed the act there. The rules have been notified on 13 November 2025. That is, the rules have been notified there. Friends, the DPDP Act was basically a principal act. That time it was passed there. And then when it comes to the rules, the entire implementation is given by the rules. If we understand the legal parlay, there is a DPDP Act and there are rules. Rules are called subordinate legislation. It has the same impact, same effect as the same force and same power as the act. That's what it draws in the legal kind of thing. Kritika will explain to you because she's a lawyer, good lawyer, she will explain to you. So 13 November 2025, the government announced the rules of the DPDP. These rules set the tone for implementation of the Data Privacy Act there. Now, as Weber was projecting it, though Weber, I apologize to you, I slightly beg to differ with you. wherever we're projecting, the companies have started looking at implementations, starting at looking how to do that, understanding to do that. And he said, he quoted some figures also there. It's, you can also, you can think it that, you can think that the companies are far away from implementation of privacy. Actually, as time doesn't permit, I will request Ms. Menon to organize a detailed kind of some time talking of the Privacy Act, explaining the nuances of the Privacy Act, which Kritika will do. Implementing the act is much more difficult. That's a real meat. How do you implement? Real challenges comes at that point of a time. So whatever time limit is there, I will try to do justice with that. So the entire Privacy Act practically has been given 18 months to implement. Some part like that act has been enforced. The definition of the act, what is the personal data, how to the what, and that has been enforced. I explained some of the keywords there. 1 more year has been given for setting up certain framework for the consent there. That's 1 year has been given. That is 13 November 2026. That will be implemented. Now, after 18 months, our entire act will be enforced. That means after 18 months, whatever these penalties are there, that will get imposed part of it. First thing I mentioned that how the heterogeneity leakage of data happens. Remember, because I will come back once again when I discuss the penalties on that part. So entire act need to be implemented 18 months part of it. As far as we are concerned, whether you are a participant or you are SMEs or you are any organization conducting business, we need to start worrying about, we need to prepare ourselves and implement a consent framework and notified by 13 November 2026. That's what part of it. The essential component of the DPDP Act is, and the underlying concept is the consent there. That any data, any service provider, anyone who takes the data from you or from organization, the consent is the essential part of it. That he or she organization takes the data, they present a consent framework notice to you, say data is to be taken for what purpose, how long data will be retained, how it will be used there. And it has to be a proper Hindi, English, and other language as per the regional language enshrined in the constitution there. So the consent is important. The consent framework need to be important. Apart from the consent manager, there should be some independent kind of a body who remain witness that consent, so and so consent was given. Otherwise, I will say I given consent to Kavita ji, and Kavita ji will bring Weber. No, he has not given any consent there. That's the purpose we have brought Kritika also in between. Kritika will be a consent manager. Another, the consent record will be with Kritika, who is a trusted party who will remain the kind of a signatory or the custodian of the data. And simple language, in a very colloquial language, don't blame me. Like oath commissioner, I go to the High Court, I go to them, notary, I signed it. What does notary and oath commissioner say? That this guy has signed in my presence. Nothing. He or she does not certify data. He say he or she has signed. You deny anything, there is an independent record somewhere with oath commissioner and notary that yes, he came, so and so, and he signed it. Someone identifies you, he keeps your personal document. The consent manager, in a way, oath commissioner, in a way, is consent manager. Don't equate exactly, just explain to you. So consent manager has to be there. So the framework of the consent manager, the restriction and obligations of consent manager need to be fixed by 13th November 2026. Consent manager will be licensed, part of license, and they will have to set up the framework. Now, What is the consent and notice? That is one part. Consent and notice is one part. The second important part is retention of the data. How long data can be retained there? That the data can be retained by two principles there. One is that the law which provides some law for income tax 7 years, GST again 7 years, some law says 3 years, some law says something else. So either go by the law or by the data collector who collects service provider collects the data, he will notify the entire policy how long he will remain the data. That's a second important aspect of DPDP Act. But data can be retained beyond that period, provided there is a notice from the court or there is some order from the appropriate designated government agency. That's the second part there. After the the period is over, data need to be deleted in a manner which can't be traceable. That means you forensically clean it, you encrypt it several times, it can't be done. That's a part of it. Now, that's the second part. Third part is the important aspect for this short time is data of the children and handicapped persons and children's. This act, as is normal in the Indian legislation framework, a children has been defined that below 18 years. That's what the children has been defined. So the children is like a voting right or a banking kind of, you go and open a bank account. The children below 18 years can provide the data, but again the principle of guardian, legal guardian, parents will come in the picture there. The government has said that the age proof service provider will be entitled to collect the age proof from a authorized agency. Authorized agency can be a government agency, like PAN card, like PAN, like Aadhaar there, your voter's card there, passport is there. Those are the kind of a authorized agencies that are there. And for the handicapped disabled children there, the government has said it should be taken from a designated agency. There is a difference between authorized and designated there. Designated is what in normal, when I declare handicap, some doctor is there who gives a certificate. So there is a nodal officer who the government will appoint who will issue the certificate for the disabled and authorization also there. Thereafter, again, your children, that parents and other picture comes in the picture. Somebody has to first declare that he is handicapped, disabled, then the parents concerned, the process which is applicable to the non-disabled children will apply and the data will be taken there. The children data carries a little more strictness, cannot be transferred, cannot be done anywhere. So that is second main issue is there. But in this handicap, there is certain exemptions there. Means if the children has to go to the hospital, some treatment like this, then these data, this whole nodal officer and the designated agency is not needed. Even the authorized agency is not needed because data is collected by the hospital, by the designated agency itself. So that is not needed. That's a second component. I will come on that. Third, that I said the concept of consent manager. The consent manager, the job is to manage the consent. The DPDP Act provides, as I said, underlying concept is consent. One has to take explicit consent in a language what understands it. And then the rules and the Act provides the authority to the data, whosoever gave consent is called a data principal, to withdraw the consent at any point of a time. That power has been given to the law, gives a power to the who provides the data, is called data principal in this act. Once the date consent is given, the consent manager is the custodian who maintains the consent there. If the consent is withdrawn, the consent manager keeps that consent is withdrawn. You can understand when a legal issue comes up, issue or damage comes up, how important becomes the role of consent manager. And the rules also provide a framework for registration, who will be entitled to apply for consent manager, how data will be maintained, how will he do. He is also subject to all those DPDP kind of rules there. The next, everybody collects the data, but then how the data will be preserved. The data required to be preserved to implementation of the best security practices. The data is not there. Please appreciate that data privacy and data security are twins of the same coins. Wherever there is a data cybersecurity breach, there will be a leakage. Wherever there is a leakage, there will be a breach. They are the twins of the same coin, so they will be there. So everyone has to implement the reasonable security practices there, and those will be notified by the respective agency called Indian Computer Emergency Response Team, which they have done, which they will do that kind of a thing. Why this has not been enshrined in the rules or the act? That you should know that. See, the Privacy Act applies to individual, maybe a partnership firm, body of persons there, SMEs, large companies, spread across the country, spread across the globe. So you go to buy Haldiram sweets from Haldiram, or you go to grocery shop to buy grocery shop. The data preservation, data security, data privacy requirement varies from organization to organization, vendor to vendor, that it varies over there. Somebody my maid servant comes to me. I did not take consent from her. She gives the data to me because as a part of the employment there, she gives the data to me. My requirement of keeping the data secure and data private are different, are much lower when you go and buy to Haldiram, to buy sweets at Haldiram, or you go to railway reservation, or you go to airline reservation, or you go to electricity part of it there. The requirements are different. So that's why the security requirements will be depend upon the entire organization depending on the deal. But the government has said, the law says that, gentlemen, if there is a leakage, there is penalty, maximum penalty of 200 crores. And if you fail to report the incident, breach incident, then the penalty is 250 crores. It's up to you. I have defined the penalty and you decide what you want to do. Penalty is defined there. You implement the security practices the way you want, but leakage should not be there. That's what we are not interested. How do you do? Though the government will notify the model guidelines, the model security framework, but ultimately responsibility is yours, organization there. Now, since I mentioned about the penalties there, this carries, there is no criminal penalties there. There are only civil penalties are also there. Why civil penalties? Because you don't know who's going to leak the data, where the data is leaked, because data is going so many places. So if you want to do the criminal kind of a things, nobody will get penalized there. Because civil, because of the evidence and all kind of thing, you can penalize it, but everybody will go through, data will be leaked out, that aspect. That's why things are there. Then there is an important concept that everyone will host a website educating the person who collects the data, user there, about the privacy policies, privacy framework, retention of the data, withdrawal of the consent notice, and thereafter, they should also say how to report a grievance officer there. There will be a grievance mechanism, it will be reported. In case of any grievance, there will be a grievance officer. User can report to the grievance officer, and the officer will deal with the grievance part of it. That's the grievance part. Now, an important concept has come up in this Act and rules, which is the significant data fiduciaries there. Significant data fiduciary means now in this concept there are three words. Data principal means like a user. Then data fiduciary who collects the data. Then there is a data processor. There can be different data processor than the data fiduciary. Data fiduciary collects the data. Data processor doesn't collect the data from users over there, but data fiduciary can outsource the job to data processor to process that aspect. Fourth important concept is the significant data fiduciary. What is the difference between significant data fiduciary and data fiduciary is that when the volume goes up of the data, like an e-commerce company, online gaming company, you see the banks there, share market there, capital market there, such organization there, which collects huge amount of data, social media, they will all get classified as a social media, though the government will notify the norms how much data it will have to be, how much significant data fiduciary, what is the threshold of the data they deal with this. These are another thing the government has put, because large data, large stakes, the law has put additional obligation of significant data fiduciary. That means they have to appoint a data protection officer to look after everything data protection in the organization, and then be answerable to the government and to the users also. So they have the additional kind of a responsibility on them. Friends, and then the most important aspect is the cross-border data. The cross-border data is the cross-border data, transfer of cross-border. When we talk about the cross-border, if I'm living in Union Territory, I can mean to be UP, I can mean to be the Gulshan, Haryana also. But if you live in India, it means to be the outside the country also. The cross-border normally is taken to be an international transfer of a data, but it can be strictly doesn't prevent it to take a domestic transfer also. Now the rule says that data fiduciary are allowed to transfer data, cross-border data, to everywhere other than few territories and few purposes there, which the government will notify. And those few territories will be like our neighbors who are always across with us, or other states where other countries where we find problematic relations, or they are economic offenders. Like critical medical data of the children will fall under that. Health data will fall under that, where also will not be permitted in normal course to be transferred outside. But the government has yet to notify that kind of a scenario, the data, what reasons they will have to notify here. Friends, these are the few things I thought I share with you. Time doesn't permit to me. And I can, if Kirti, you are going to cover up what they need to do, otherwise I can cover up that part also there. The time is already 3:35. But particularly in the implementation, what is the immediate requirement we need to do? The immediate requirement, as Vaibhav has projected in the second slide there. Today, Vaibhav, please pardon me what I am going to say. In my understanding, 97% organizations in India are not privacy compliant. That's my understanding. I'm so sorry. You and Kritika should be happy, because it opens a green field for both of you for offering services there. Okay, but then it opens a green thing for Miss Manan also, that she has so much promotional work to do, so much awareness need to be created there. That also factor is there. So what need to be done? As I said, this law is applicable to each and every one in the country. Such a big, large application. With 98% organization not following thing, even those organizations who have a office here, they're part of the multinational. They have implemented privacy law as per the European so-called GDPR act there. But though GDPR and here more or less same, but still need to be customized, tuned, and all kind of a scenario there. So immediate action point need to be taken is that first point that we need to create a DPDP compliance framework. Means we need to do the gap assessment first. And that first part of the gap assessment in terms of where is my data lying there, how my data is flow there, and where are my data assets there, who is managing them. That's the gap assessment we need to do. We need to track the entire data flow. So part of the gap assessment, create a DPDP framework. And under DPDP framework, we need to create a privacy policy and we need to create a security policy aspect there. We need to create a consent framework there. The form for the consent, how to take a consent, where to take a consent, what data is needed from me, how I can withdraw the data, how can a principal can withdraw the data, how can I change the data also there. That part is also there. Now the norms on the limitation and data minimization. Because the data, I mean, today, if you go to anywhere, a whole collector of data is there, very difficult to fill the form there. I mean, if some banker comes to me for a credit card application, 4-page form is there, I'm not able to do, it takes my blank signature and goes there. That form will get revised because only minimum data what is required is need to be taken. Aspect, we need to announce a retention policy, how long data will be retained and for what purpose data will be retained there. Then establish a data breach response system there. Means if the data breach is there, how to report it, how the organization will report to data protection board. That's the second part comes up, security standards there, training awareness. Most important aspect where Kirti and Vaibhav is involved. Most of the function happens in India in an outsourced manner. I outsource my work somewhere else. Now my data goes there. You see the credit card, everyone is outsourced to someone. Someone else is managing. The bank is not managing it. Aadhaar, you see someone else is managing. They are not managing. The data goes out. So I may not be leaking data. I may keep the contract, implement the framework, but my vendor doesn't do that. So the contract management means my hoods or my outsourced partners are there. They also need to implement the framework as per the law. Both need to be done. The security of the organization and the security of the outsourced vendor should be in the same line, same standard of security should be there. That's what the important is there. See, friends, it's almost had taken more time. There is no generic approach. Though I have discussed about the generic approach, there is no generic approach. Every approach has to be customized as per the requirement, and the law is quite flexible and open from that point of view. The entire thing is very, very important, very, very serious. And even if I go by the rosy picture which Vaibhav has given that, it will take time, and the time is click has already started on the 13th November 2025. More than a month has been passed. I think we have only 11 months to do that. We need to hurry up and we need to look at our systems, our data, and then start implementing. We need to be serious. Thanks very much for giving me the time. And I whatever time allotted to me, I have crossed that time. But whatever justice I could do, I can do. But I think Miss Manon knew about it. That's why she has kept more than an hour for our question hour. We will explain that. Thank you very much, ma'am, for giving me an opportunity.
Thank you so much. In fact, we already have some questions in the chat. I had just written to all the participants that while you listen to all our speakers, there'll be questions that come to your mind, but we do not want to, take the questions right here when the webinar is on. We will take up all the questions after the webinar is completed so that we'll take them all one by one. So now over to Kirti Mahapatra, partner Shardul Amarchand. Request you to kindly address us on the various techno-legal issues. Thank you.
Thank you, Kavita ma'am, and thank you, sir, for that really detailed insight into this law. I know it's been in the making and also has been for us to review around for more than a couple of years now. I'm going to take from what Dr. Rai has said. In fact, there were a lot of key points that he has made, and maybe try and contextualize what organizations should be thinking about in terms of how to use the next 17 months and what are those more critical high risk issues that they should be thinking about, depending on where in the spectrum you land in terms of being a privacy mature organization, if I may say so. I'm also going to share a presentation just so that we have something to see. I'm sorry, is my screen visible? Thank you. So for the next 10 minutes or so, I'm just going to very quickly talk about what does it mean to build towards DPDP compliance, given the fact that we have about 17 months, like Dr. Rai said, to move to compliance, and especially in light of the fact that we are looking at some really big penalty amounts here. One of the points that Sir made initially was that in India, data is collected everywhere, and that is such an important point he has made. And this is one of the key issues we as lawyers, help our clients understand even before we, go into stages around building, a compliance program, trying to understand what gaps there are, and how exactly do you move towards becoming a more privacy compliant organization. There has been a lot of discussion around privacy by design, etc. But even before you get to building those sorts of privacy enhancing technologies or integrating them into your systems, what you would first need to do as an organization is basically understand what does your organization do in terms of data, right? And in the slide before you, we basically see this entire structure in three parts, in three phases, if you may say so. The first phase of the DPDP compliance, according to us, is the foundational phase, where you're doing a lot of the groundwork to basically identify where does your organization deal with data? What is the data life cycle, if I may say so, within your organization? So the first very critical part of moving towards compliance is basically doing this foundational work, which is doing data discovery, doing purpose mapping, and then identifying where you lie in the DPDPA ecosystem. Now, let me explain this a little bit, and I think there is going to be a lot more detailed discussion about this stuff, so I'm not going to spend a lot of time on it. But the idea behind taking that first step towards DPDPA readiness is to basically chart the entire life cycle of personal data that your organization is handling, starting from the stage of where you start collecting the data to the point of its erasure or removal from your organization's assets and systems. The idea should be that of this particular work is to basically find each and every source through which personal data is flowing into your organization. The reason we focus on this so much is because, like Sir said, data is collected from everywhere. In India, there is a general tendency that we may ideally collect more data than that might be required. So the idea of being DPDP ready is to first understand what is the data we are collecting, why are we collecting it, what is the purpose for which we are collecting it, and then what are we doing with it, right? Irrespective of whether or not we have security practices in place or whether we take consent, etc. Those are compliances that come in later. What we need to understand is, what do you do with that data? Where does that data get stored? Who has access to it? Does it get transferred to other countries? Does it get go to vendors? How long do all of these third parties hold on to this data, right? The reason we focus so much on this sort of identification is primarily to do one critical aspect of analysis, which is to determine whether you are processing data as a fiduciary or as a processor. Now, processors obviously fall outside the scope of the law, but that does not mean that they will not have anything to do with the DPDPA, because the law is pretty clear. It says that data fiduciaries have to ensure that all processors processing personal data on their behalf do so under a very specific kind of contractual obligation. So as a processor also, you are going to see passing on of contractual obligations to you under this law, and accordingly it is extremely important that each organization make a determination of whether they're a fiduciary or a processor of data. And again, this sort of a assessment is not a, if I may say so, one-time fixed assessment. This assessment changes depending on what is the data being collected and how you're using it, what are the purposes for which you're using it, and what role do you play with respect to that data. As a part of the data discovery process, we said that purpose identification is also extremely important, because purpose identification takes you to the next level of compliances, which is determining whether purpose is based on consent, whether it is based on legitimate uses, which are contemplated in the law, or are we falling into an exempted category of use, which basically means that we may not need to do compliances with certain requirements under the law. So as you can see, all of these initial assessments will become important for you to even understand what is the matrix of compliances that you have to basically deal with, and will help you in phase 2, which is to build towards readiness. So even before we get into reviewing contracts, even before we look at vendor screening or data breach protocols, how we enable data principal rights, foundational work is very, very critical. And this is where techno-legal measures are also very, very important, because data discovery is in our experience not just a manual process of answering questions of where you have collected data from. It can also include implementing technical measures to actually do data discovery within your organization's digital assets, because there might be many touch points with personal data that organizations may or may not be aware of. This is the reason why it is basically a combination of manual as well as technological discovery of where the data touch points are. Now, like I said, this is basically the first step towards preparing for DPDP. Then the next phase is to build towards compliance. And this is where gap assessments become important. Once you have an idea of the kind of data that your organization is collecting and what they're doing with that data, the next step is to basically then do a gap assessment of the requirements of the law. Now, gap assessments, like Sir said, there is no one general framework that fits all. There has to be customizations built in. Gap assessments have to be, in our experience, highly unique to the organization and its practices. These gap assessments will focus on what level of compliance you as an organization are already undertaking. You may be GDPR compliant, you may be IT Act and SPDI laws compliant, or you might be doing certain compliances because you are a service provider to a regulated entity in India, like a bank or a financial services entity or an insurance entity or a healthcare provider, for example. And you as the processor of their data might be already doing a bunch of compliances because these are contractual obligations on you. So the gap assessment process is very organization specific and is basically designed depending on the foundational work that goes in. That first phase where we basically make determinations of the type of data you're collecting and processing, what are the purposes for which you're using, the roles that you're playing with respect to the data, which makes a determination of whether you're fiduciary or processor or both. And this is what feeds the gap assessment, and then identifies how, basis the uniqueness of the DPDPA, what are the different protocols, changes, be it process level, organizational level, or even at the level of product, that has to be implemented to be able to do compliance with this law. Now, some of this will, of course, include building consent management architectures. I'll come to that in a bit. But the idea is that the gap assessment has to focus on basically understanding where you stand today as an organization when it comes to complying with any kind of data protection law, and what you have to do to take you to compliance with the DPDP Act. Now, beyond this, of course, once you've started building, the final phase would basically mean organizational implementation, which is basically the full life cycle of compliance, establishing security practices, having your playbooks in place, and then ultimately negotiating and putting in place your policies and contracts. This is how we see the next 18 months, or rather 17 months now, charted out for most organizations in India with respect to the DPDP Act. Now, coming to the more, a few high-risk areas that organizations need to think about. Like we said, one of the key factors of the Indian law is that there are very limited grounds on which personal data can be processed. One is consent, the other is legitimate use, unless you fall into certain categories of exemption. Now, on the basis of the purposes that have been identified, and depending on whether those require consent or not, there is a requirement to build consent architecture within your organization, how you will collect consent. So what is going to be the user experience with respect to consent? Again, because there are very specific requirements under the DPDP Act about how notice has to be given, who it has to be given. The fact that there is some level of, a look back period in terms of providing notices, what we call legacy notices for data that the organization is already processing. So there is a whole bunch of requirements when it comes to how notice and consent has to be managed. It is one of the most fundamental things, compliances that all data fiduciaries have to do. And it will take an immense amount of technical measures as well as legal measures to be put in place to be able to come to a point of compliance. I'm not going to go into a lot of the detail, but basically, like we said, basis the data discovery and mapping process, evaluations have to be made by organizations whether consent notice that they currently use or are not using at all, what is basically the level of compliance you're at. If you're using consent notices, are they adequate for the purposes of the kind of processing you're undertaking? What does affirmative consent mean? Are you actually taking affirmative consent, or are you doing consent by implication? All of these questions have to be answered. UI UX has to be understood and designed also, wherever there are gaps to meet compliance under the DPDP Act. So here also, again, there has to be technical tools involved in how you create your consent architecture. And of course, a year from now, you will also understand how your consent architecture has to take into account the fact that data principals might come to you through their consent managers, and how integration of the consent managers technological system has to happen with your systems, your consent management architecture, to allow for interoperability so that there is free flow of consent and other decisions around the manner in which that individual's data is basically going to be processed by you as an organization. And of course, like Sir pointed out, there is also the very critical aspect of verifiable consent. So any organizations who are dealing with more protected categories of data, such as child data or data of persons with disabilities who have legal guardians, they will have additional consent infrastructure to build, because they are expected to, again, collect additional information while keeping, like Sir said, data minimization as a core principle going forward in terms of data collection. Moving on, the next big question with respect to the kind of measures you'll have to put in place is, of course, to do with data principal rights. Now, again, I don't want to go into a lot of detail about what these rights are, but what we wanted to call out was that irrespective of the kind of processes your organizations may be following, and certain organizations may already be at a high level of maturity when it comes to dealing with grievances, for example, data principal rights is something that in India today may not necessarily be a very if I may say so, well implemented practice, even though there are certain basic rights for individuals whose personal data is getting processed today under the IT Act. There are certain rights that do exist. But to what extent those rights are actually enabled, what does the system look like, and to what extent, what is the sophistication of that internal system that you have? Because it's not just grievance redressal, it's about withdrawal of consent, it's about the ability to get data principals to access their data, to update it, and then having that change basically reflect across your entire data management lifecycle. So internal updates that have to go to the level of the vendor, to third-party service providers. All of this, again, is going to require technical support, technological support, because depending on the volume of data that your organization may be dealing with, there is a high chance that, for example, having a manual system of dealing with data principal rights may not necessarily be sufficient given the kind of compliances that are contemplated under the DPDP Act. Moving on, another high-risk issue that we wanted to call out was data breaches and breach reporting. There is a reason why we wanted to specifically focus on this. One, of course, is that given the very wide definition of what a data breach is, data breach also includes accidental processing of data. Now, accidental processing might mean processing data without consent, processing data beyond the purpose for which it was collected, the time period, etc. Now, the law does not make a distinction between a malicious breach versus an accidental breach. So it becomes very, very critical to understand that a lot of the work that you do at your build phase in building your consent infrastructure and managing consent and purpose mapping, etc., is very critical to how you will come up with your breach reporting and your breach identification policies. And data breach, like Dr. Rai pointed out, is basically the contravention that attracts the highest penalty under this law. And it is extremely critical that organizations make sure that they build towards ensuring that they keep in mind the fact that data has to be processed in a certain way. And this sensitivity is not restricted only to certain key managerial or key functions of the organization, such as legal or IT, etc. Data processing happens across all teams of any organization, starting from HR to security to vendors to like I said, IT, legal, managerial staff, etc. Everybody processes personal data. So with respect to data breaches, it is critical that not only do you build for compliance, but you also talk to your organization leads and every team that touches personal data as to what is the importance of privacy, what does this law mean, and why are policies being put in place, because creation of the policy is one part of it, but organizational awareness and maturity towards how data is being processed by each function, especially if it is personal data, is also extremely important. And personal data breach reporting is where we see the maximum amount of measures that organizations will have to undertake, primarily because not only are we looking at identification of data breaches, we are also looking at how it has to be managed, because reporting is a two-phase reporting. You're not only reporting to a regulator, you're going to be reporting to each individual whose data has been breached. There are different protocols on how that reporting has to happen. The contents of the report change slightly. There is an entire process to be followed about the data breaches, and then to add to it or to layer onto it, we have our overlapping requirements coming in from different sectoral regulations, which basically means there is a possibility for reporting to multiple regulators, not just the Data Protection Board. So all of these issues have to also be kept in mind when developing internal breach management protocols, policies, systems, etc., all of which again will require high level of coming together of technical inputs as well as legal inputs on how the organization designs these sorts of compliance programs. And finally, we wanted to touch upon cross-border data transfers. Now, under this law, the default position is that status quo has to be maintained, which is that data continues to flow freely across the borders of India, subject to any specific sectoral requirements that might exist. And there are a few, at least in the banking and finance, banking, financial services and insurance sectors. And there are certain incremental obligations which are contemplated for significant data fiduciaries, but that is also subject to further information coming in from the Government of India as to whether localization has to occur or not. But all said and done, cross-border data transfers has to be not looked at only from the perspective of data localization only. It has to be looked at from the perspective of the fact that there are other entities which are going to process data that was primarily collected by one organization. So how do you keep the chain of control? How do you apportion responsibility? How do you apportion liability? What does it mean for that other third party entity to have had access or have received personal data from you? Are they playing the role of a processor? Are they playing the role of a fiduciary or a co-fiduciary? These are all critical questions that have to be answered. It is a fact that this law has extraterritorial applicability. So cross-border data transfers, understanding where your data is flowing, creating a data flow chart at the very minimum to understand what are the different organizations to whom the data is flowing is also very critical, because it answers questions about the data that is collected by you as an organization. What is the role that all of these third parties are playing with respect to that data? How do you then contractually put in place safeguards to ensure that your compliance is not compromised? And also, how do you ensure that these third parties who are receiving data from you or processing it on your behalf are ensuring that you are enabled to continue to do compliance with the DPDP Act? So these are some of the more critical questions and risks that you have to keep in mind when you are coming up with your DPDPA compliance plan. I'm happy to answer any questions you have, and my apologies. I know I have overshot the time, but like Sir said, there's a lot to unpack here, and I hope this has given you a snapshot of some of the more critical issues that you need to think about when you're thinking about the Act. Thank you.
Thank you, Kirti. That was really, really nice of you to have taken us through the various steps and all what needs to be done, and of course, highlighting some very important areas. I would now move on to Mr. Vaibhav again to give his address and maybe through a presentation, a phased practical roadmap to DPDP readiness aligned to the organizational maturity.
Yeah, thanks for this, Kavita. So, and thanks, Kirti and Dr. Rai, for providing all the insights. So, as we kind of start off, this is just a very quick snippet of all the requirements that are there as per the DPA, depending on the different type of entities that would require to satisfy them, right? So, we have categorized the government has categorized them into three broad buckets: the significant data fiduciaries, as well as startup and other similar fiduciaries. So like Dr. Ryan Kirti already mentioned, the significant data fiduciaries are the ones which have maximum of the requirements coming into play. And the additional requirements that they have are mainly focused on doing data audits, which basically are privacy focused audits that need to be done on a periodic basis. Then doing data protection impact assessments, which are basically detailed risk assessments from a privacy perspective, looking at it from a process by process perspective of things, and also having a data privacy or a data protection officer within the setups, right? So these are some of the key requirements that we have among all the others that are out there. So we'll quickly go through a quick roadmap in terms of what is generally required for getting this compliance done in the 18-month period that is being provided to us, right? And what you see on the screen is just a quick summary of the key steps, and the flags indicate whether these are applicable to significant data fiduciaries, or any smaller entities like startups, right? So when it comes to significant data fiduciaries, one of the key requirements is to have a data protection officer. So when it comes to the regulators, one of the key things that they are going to ask us in case of the significant data fiduciary is not what tools or technologies are going to be leveraged or utilized, but the first question is always going to be about who is accountable for it. So that's one of the key things that is required out here to have a data privacy or a data protection office set up, or have certain key personnel or representatives manage the end-to-end process from a privacy standpoint. The other piece which has been talked about quite a bit is on the consent and preference management standpoint of things, right? So a lot of organizations were taking consent earlier as well as part of certain other requirements in case of BFSI, be it the lending guidelines and other guidelines out there. But with the DPDPA, the requirement of taking consent is more or less continuous. When I say continuous, what I mean is if a consent is taken for a particular purpose, then that information or that personal data can be leveraged and used only for that purpose. If the purpose changes, the consent needs to be taken again. So as part of the implementation plans, the organizations need to look at all the customer related journeys from where information is captured to the time the information is retired, right? So when we look at it from banking or be it from a e-commerce standpoint, wherever customer acquisition is happening at that point till the time the services are being provided to the time that the information is no longer required. So it is extremely important to kind of take care of this process, be it in terms of defining the consent related language, having the documentation properly done around it, having the right level of consent forms set up, and also the technology related elements added over there, right? There's a focused requirement of having privacy notices as well, which need to be taken care of. Another piece is on uh, considering that this is a detailed exercise, it is definitely very important to have the right level of data privacy related policies and procedures at an organizational level. While policies and procedures are not going to be some things that will lead to a penalty, but the operationalization, if it is not done properly, definitely there can be significant penalties that need to be taken care of. The retention related guidelines and the procedures need to be updated on a periodic basis for organizations. So some of it could be based on your organizational policies, but the DPDPA Act, DPDPA as well as the rules also provide additional guidance in terms of storing personal data related transactions and related information for a permissible time of at least for a period of 1 year, or when to the timeline of whenever it is required for the processing, right? So, and beyond that, the principle of data minimization should be used wherever the consent is revoked and the information is not to be used further. And that information should be retired by giving a notice to the customer beforehand, right? Apart from that, once the policies, procedures, guidances are kind of set up, a detailed implementation plan needs to be set up, and that organizations need to take care of. And generally during the implementation phase, and in fact, we earlier talked about the gap assessment piece. Along with the gap assessment, a detailed data discovery, data cataloging within the environment needs to be done, because one of the critical issues that all organizations face today is the awareness of what all information is stored where for what process, that itself is not available. So detailed workshops or technology related platforms can be leveraged to have that identification done, data personal data registers be created basis that, and that can help us go to the next few steps over there, right? Another critical aspect that was talked about was on data subject or data principal rights management, right? So this is extremely important for organizations, because as soon as someone withdraws the consent or someone kind of requests for a update to their information, all those pieces need to be promptly taken care of for the customer. If we are not able to do that, there would obviously be an issue in terms of customer trust, but obviously if the requirements are not met, the penalties also do come into play. So this is an important aspect that needs to be taken care of, and this is something that should be provided in a easy manner for the customers to be able to update their data whenever they want, and should be kind of a help desk type of a setup. We already talked about grievance redressal related pieces. So generally implementation of specific addresses to set that up, be it on an online address, or be it something like a chatbot. In addition to that, helpline as a phone number, those things would need to be set up. Now, apart from this, apart from the privacy related controls, another focus area is also on the security related controls. So be it related to logging, be it related to access management, and so on and so forth. So the mammoth requirements which are out here with respect to this act, they can't all be taken care of manually. So it is extremely important for organizations to use technology for this. So be it data discovery tools, be it consent management tools, data rights management related setups, as well as security tools related to data leakage prevention, identity solution, encryption, and masking. So all those would be critical to kind of enhance. A lot of organizations would have some or the other of these setups done, but it is pertinent to have them enhanced, add new technologies to it, so that we are able to manage the requirements in a proper manner. The other important element that Dr. Rai also mentioned about is third parties, right? So when it comes to third parties, generally whatever work the third parties do for a organization, be it a data fiduciary or a significant data fiduciary, they would potentially act as data processors. So as per the act, all the obligations, be it related to penalties, be it related to any punishments that come into play, they are focused on the data fiduciary itself. The act does not make the processors liable directly, or the third parties liable directly. So it is extremely important that all the vendor related contracts that are out there, wherein processing of personal data is involved, we need to have a proper data processing agreement set up with them, have the contracts updated in a manner wherein back-to-back arrangements can be made. Whatever required safeguards are needed for the organization to function basis the DPDPA, those should be passed on as well within the vendor contracts. In addition to that, periodic third-party vendor assessments should be done on a regular basis. We already talked about breach response related procedures. So this is something wherein certain related requirements had already been there. A lot of organizations are already sending these responses as well. But this has now become more focused on the privacy standpoint of things as well. So the right level of measures, the right level of technology components also need to be there. So if we have to respond to the data protection board within 72 hours, we need to at least have the right level of setup, the security operations centers, the incident response related processes and procedures to be there to be able to do that. So a typical example in this is incident really happens Friday evening, and still deliberation is going on till Saturday, and then finally by Monday we decide that, hey, whether we want to go ahead and report it or not. And by this time, the timelines are already taken care of, right? We are already in breach of timelines. So those are things that we need to look upon in a very focused manner. Similarly, having data protection impact assessments being done on a regular basis, having the right level of templates made for those, and then in doing compliance assessments and annual audits. So those are some of the key things that need to be looked upon from an overall implementation standpoint. So this was just a very quick snippet of how organizations need to kind of take care of the implementation. And broadly, we need to kind of look at it from an external facing standpoint and an internal facing standpoint. The external facing being the customer. So anything on the consent piece, anything on privacy rights management. Those things should be taken care of on one side of the task, and anything internal, which is your internal agreements, internal data discovery, processing, all those pieces, they should be taken care of in parallel as well. Right? So these are some of the elements that we need to kind of look at. Apart from this, obviously, there's always a lot of buzz around the use of AI, right? So these days, the CISO teams, DPO teams are also trying to leverage AI on the privacy elements of things as well. So with respect to the various requirements which are there are certain elements of co-pilots where a lot of help can be provided. So a lot of privacy enhancing technologies which are used for consent, for privacy notices, they have started to build in AI elements to them. But in addition to that, additional co-pilots are being POC'd in a lot of organizations. So be it related to training related purposes, be it related to consent management, be it focused on contract reviews, all those elements also, a lot of use cases on privacy are being kind of focused on now. So with this, I'll take a pause out here and pass it back to Kavita, and we'll be kind of happy to take any questions. I'm sure there'll be a lot.
Thank you so much, Vaibhav. In fact, while the presentations and the addresses from the speakers were going on, we've been having these poll questions on the side just to understand, as to where each one of us are, in their journey. So I would request either Satish or Vaibhav to kindly share what the questions have revealed to us, what percentage, and what is it that what our findings are. Would you like to do that, Satish?
Wait, just a second. So I think I'm able to see some of the poll results. Right?
Okay, fine.
So one of the pieces was around who currently owns the DPDP compliance within the organization. So some bit of it, I think majority is still kind of saying that there's no clear ownership, and this kind of pretty much resonates with what Dr. Rai also mentioned, because these are still pretty early days for most of the organizations. So in certain cases, the CISO teams or IT teams are kind of taking care of it. But in certain other cases, it's still kind of like a mixed bag, and it seems to be somewhat similar to what we had seen in our earlier poll as well, right? The other question that was there was focused on which DPDP rule worries you the most, and I think the maximum response is on consent management, and I believe this also pretty much resonates well because for most of the organization, it is the customer that is extremely important. While the internal work or internal processes are being focused on, customer trust is important, and I believe that's the reason why there's a lot of focus on consent management and the related platforms implementation as well. So apart from that, there was a question which was focused on, has your organization done a POC on any of the following yet? So this is related to tools such as consent management, TSAR processing, so on and so forth. And I believe the answer related to that also is more focused on the consent side and the TSAR side at this point in time. So it pretty much resonates well with what has been discussed out here, and I believe it kind of gives a good insight. Right. I think Kavita, maybe
Okay.
we can go
So
ahead with
if,
questions.
yeah, so I think, we have some questions while the speakers were, completing their address. One of the questions is from an IT and cloud operations perspective, what are the minimum mandatory security and governance controls organizations should prioritize immediately to meet DPDP compliance, especially in cloud native environments? I mean, Vaibhav, you or Dr. Rai or anyone could take this question.
Sure, sure. I can take a stab at it. So one of the things with respect to DPDPA is it is pretty much all pervasive. So as long as personal data is present, be it on any of the technologies or be it any industry segments, all the related compliances are required. But that being said, being a cloud environment, some of the things become slightly easier when it comes to data discovery, because most of the information tends to be either structured or unstructured, and you generally have certain connectors easily available for cloud environments. A data discovery can be quickly done, so that could be one of the quick wins to be taken care of, so that you are fully aware of what information is stored when and where. And wherever any personal information has been taken in, it's extremely important that the right level of consent is taken, by taking care of all the other requirements, be it the languages, the notices, all those things need to be definitely there. So these, I would say, would be the quick wins to kind of start off. While I'm calling them quick wins, it would still be a implementation journey of maybe uh, six 6 to 8 months, where an end-to-end implementation can be done if these are large workloads. But apart from that, the process-related elements and the legal aspects, they also need to be kind of taken care of.
Another question is there a need for a data protection officer for each clinical project?
I don't know, Weber wants to take it up, wants to do, I'll take it up. I would do the younger slot, but I just want to add what Weber said about the cloud. Questions were specific about the cloud. See, though I said that privacy and security are the two sides of a coin, there's a twin, but still there is a difference between these two. There, if we are implementing a framework, we are not talking about privacy. We are only implementing framework to secure our data and within our cloud. But when it comes to privacy, when the data goes out of the cloud, which I have said in the beginning, I said yes, with Kitika also quoted there, then the issue of privacy also come to the picture there. So what question was dedicated to cloud security framework. As I have said in my presentation, the rules or the act does not provide a elaborate security framework for that. And why it not provided, I also explained to that. So the security framework for a cloud would have been there provided by the MIT or CERT or NCIIPC. They would have done that, follow that kind of a framework, because the rules and the act also depends on them. They need to follow the framework, as Weber also said, has been notified by directed by the concerned agencies. So in this case, it will be MIT, CERT, NCIIPC, and in case of the regulators like financial institutions, the RBI, SEBI also have notified a security framework. They have so far not notified the privacy framework. They will come around that because the act and the rules provide them to lay down their additional conditions with respect to the privacy, but they have provided a elaborate security framework for clouds and in general aspect. So that's I thought I'll add to the above kind of a thing. I will request Kritika to
Thank you, sir.
address if she wants.
Thank you so much, sir. Just a couple of extra additional points. Completely agreed with what Vaibhav and Dr. Rai have said over here. The sectoral laws, of course, become highly important, as well as the multiplicity of regulators, because the question is focused on security and governance controls. The DPDPA, like sir said, is principle based. The rules do provide certain inputs on how implementation has to be done. But if you look at the security requirements that are provided, they are Again, sort of principle based, primarily because flexibility has to be given to organizations to design their own security protocols. So keeping all of this in mind, I think what needs to be done in terms of prioritization is to basically understand how does this entire network of laws and regulations basically impact your organization. You have to create a baseline of what is the bare minimum you have to do in terms of security practices that you have to build in. And then depending on the nature of data you're handling or your operations, etc., certain specific requirements will also have to be built in. For example, when WebHub said that most data fiduciaries in India currently do not have a data audit requirement unless there is significant data fiduciary, you must have to be aware of the fact that CERT itself has come up with recommendations around data audits, especially if you are adopting software and AI. So, we have the AI and software bill of materials regulations, which have recently come in, which do specifically talk about certain kinds of audits that need to be undertaken. Those audits have, of course, already always existed under the aegis of the RBI and IRDAI and SEBI, etc. But yeah, what needs to be understood is what are the different laws that impact you and your operations, and to basically create a baseline of what security measures are absolutely important to implement, and then build to more specific requirements thereafter.
So there's a question for you, for Dr. Rai. How can we protect our data if it is leaked even after privacy policy is in place?
How will protect the data
if it is leaked even after privacy policy is in place?
Let me understand the question first. Privacy policy is in place, or when this act finally gets implemented? The answer will be slightly different, both the cases there.
Yes, correct.
So kindly, I mean,
We will just
let
ask
me
them
take-
to elaborate. Yeah.
let me explain both, because the time shortage may be there, other people may
Okay.
get it.
Okay.
See, I mean, if it's a question, general question, that how to protect the data, the privacy policy is in place. If the privacy policy only talks about your intent, what is your policy? It does not give anything. How do you implement? Privacy policy is the first step. Kritika said it. Implementation is the second step there. So you have to look into your implementation even after the privacy policy is in place, data is leaked out. You have to look into your implementation. And that's what I also said, Kritika also said, and Vaibhav also said. Gap assessment of data flow, assessment of data assets is very, very important aspect there. And I don't want to go into technical aspects there. As I said in my thing, talking about the policy and framework is different than technical implementation. It's really a challenge, technical implementation. I can tell you the capital market will undergo heavy challenges when you start implementing it there. How do I preserve my data? Means if I have a database, data set, ultimately I will be required to segregate the personal data and rest of the content. Personal data, I may have to anonymize or encrypt it, then the rest of the content data. So even if the content leaks out, you can't identify that data belongs to person A or person B, you can't identify a person. So that is become the privacy part. But once the privacy policy is there, implementation is a crux. And if the data leaks out, you have to report to data protection board and get ready for the fine there. Only thing you have to prove that this is a inadvertent part. You have implemented a policy, you have audited a policy, and you have taken all the due diligence to protect the data. There, that's all you have to demonstrate in a concrete terms and concrete manner there. If you are able to do, I think the DPDP will certainly not leave you with a caution that please be careful in the move. But if you are found weak in terms of data privacy policy, not proper policy, in terms of implementation, data flow, data assets there, data or data audits there, not complying with audit, yes, there will be a problem there. Only thing what will matter after the act is implemented is the reporting the privacy breach to data protection board. Rest of the thing is applicable today also. Though there is no, though today the Section 43 of the Information Technology Act is in force there. That covers the privacy. And that only says we need to have a best security practices, which is nothing but ISO 20001 in place and implemented, get it audited, system be audited minimum once in a year. And as and when you significantly enhance, change the configuration, enhance this configuration by virtue of software or hardware.
Thank you, sir. Another question is, what is
Sorry,
the
Kavita,
role
if
of...
may,
Yeah, yeah,
if I may
please.
also just
Go ahead.
add into what
Go
Sir
ahead,
has
yeah.
said. I know that this is a very open-ended question and a lot can be said here. But the privacy policy is, like Sir said, just literally the first step. The other thing that I wanted to call out is that everything that Sir has said as measures that you need to think about when it comes to security, please note that if you look at the scheme of the DPDP Act, it is very clear that if enforcement action happens, Data Protection Board is going to impose penalties based on certain factors. One of the factors is the kind of measures you have taken as an organization to protect the personal data that sits with you. What sort of immediate actions you took in the event of a breach to protect the data, etc. So these are all critical questions that will come into play if at all there is regulatory action taken against an organization. So having these sorts of protocols and policies in place and actually implementing them on a day-to-day basis is extremely critical. So this is not just documentation. There is a lot more to be done here to be able to demonstrate to the regulator, to the adjudicator, that we did everything in our power to protect that data, but it has that a breach has still occurred. And also, ma'am, sorry, I think there was a question on DPOs. So data protection officers have to be appointed only if you are a significant data fiduciary. Otherwise, you are supposed to have a person who's the main point of contact when it comes to data protection rights. Basically, a person that your customers, etc., can write into if they have questions or if they want to exercise their rights under the Act. This is not specific to any. It's an organizational compliance. It is not specific to individual projects. But again, I'm not sure what you would mean by a clinical project. But I thought we should just answer that question.
Kavita ji, I think one point need to be highlighted. I don't know. I did not highlight. I don't know whether my other two young panelists highlighted. There is a penalty on the data principle also in this act by rupees 10,000. If you report wrongly, if you don't follow the proper practices to protect your data, or if you are in habit of just reporting, putting the fault on someone else, you are not taking your step properly, then the board can put penalty of 10,000 also. So this is the first act in this country where the civil penalty has been imposed on a users also if he doesn't follow the rules and regulations.
Very important. I think this is very important to know as well, because as we move forward, all these things need to be cleared. In fact, this also answers one of the questions that had been put up in the chat as to what extent does the DPO, that is the Data Protection Board, what extent does it have punitive powers? So I think we just spoke about the Data Protection Board over here. Would you like to elaborate on this, sir? The role of
Data Protection Board is already in force from 13th November. Government has yet to notify who are the board members. The first year will be only making regulation, their processes, how to do that. As Kritika said, there are certain set of rules which has been done. They have the penalties, the 250 crore, 200 crore, 10,000 crore maximum has been put there. See, penalty will depends upon this actual amount of penalty will depend upon the kind of a carelessness, kind of a data leak, kind of a protection measures you have done that organization, that depends upon that. That depends upon that. Imagine that every IPC or any law gives a punishment of, let us say, 7 years, 2 years, 3 years. Magistrate never gives, if the punishment is permissible, if is maximum 3 years, never gives 3 years. But if repeatedly some offender is doing repeatedly trying to commit an offense, their punishment will go up. But I mean, I can tell you a practical aspect which I can take the liberty from everyone. See, it's a first act, and in my understanding, 98% organizations they don't meet it. So it will take time. It's quite difficult, challenging part of it. What is needed that get ready, stand on your feet, start putting the process and start implementing it. A lot of issues will come when the outsourcing part of it. A lot of issues will come, legal contract, outsourcing issues will come, and many questions comes there. Very intricate question comes up, which all of you fail it. Don't worry about it. Implement whatever best you can do in 1 year's time. And I think the data protection board will be quite reasonable for some time in deciding the penalty if there is a data leakage. I can't say if there is sheer carelessness and there is no measure has been taken, then certainly I don't think any kind of a reasonableness will happen there. But as long as all measures are there, steps have been taken, I think first year they will be very reasonable in imposing penalty.
A different kind of a question has come in. Is there any government body like CERT-In that will issue certificate that the specific company is DPDP compliant?
No, first of all, CERT does not issue certificate. CERT only impanel auditors for the purpose of security and privacy. Okay, it is not mandatory that anyone take from that impanelment. They can choose any auditor from anywhere else. The CERT only does because they evaluate the auditors thoroughly. So they think, I mean, though it is normally a reference guidance is done, they choose some impanel because someone has already done that critical assessment. But there is no agency in the country, government body authorized who will issue the certificate. It's a different certificate. There's not. The auditors will be impaneled and the auditors will issue the certificate. Those auditors will be impaneled there. Like this auditor which I talked about, CERT impaneled, they are impaneled by CERT-In. They issue the certificate. If there is a issue in the certificate, if there is a fraud is there, I mean, CERT is a body where you can complain there, but CERT does not certify those certificates. Similarly, privacy also, there will not be anybody, the rule doesn't provide that. Tomorrow it may come up. There is nobody who will certify the policy other than the auditors.
Thank you, sir. In fact, there were a lot of similar questions that have been answered while each of the speakers were, just answering to the other questions. So if there are no more questions or if there is anything that Weber, would you like to add anything?
I think I would only like to say this is one of the very pertinent topics of the times, and one of the things is we all look at it as a regulation which is extremely important to comply with, but a lot of organizations would also start taking this as a competitive advantage. The moment organizations start complying with the act in a fairer manner, providing the right consent, having the right level of usage over there, the customers will also start trusting them more. So that's one of the pieces that we should also all keep in mind as organizations and kind of take it ahead.
The one question was flagged on the screen, employer and employee. The Act and the rules provide that employer can collect the data and that is exempted from the Act. When it says exempted means consent, because the data, he has already given consent. When it becomes an employee, he has already given the consent. He gives the data, only then he becomes an employee. Appointment letter issued only when he employs. But employer responsibility of the employer is that they don't take another consent and they don't leak out the data. If they leak out, the DPDP will apply on them.
Correct. There's another question focused on ISO 27701 certification. So they're asking whether it covers DPDPA compliance. So ISO 27701 is a privacy management certification. So ISO standard similar to the one which they have for security. Now this one is focused on privacy. So it helps organizations have a fair methodology of managing privacy, having the right level of controls also. So whoever is kind of compliant with ISO 27701, they would definitely cover a lot of requirements of DPDPA as well. But then a little bit of customization for the local needs of DPDPA would definitely still be needed. And that should be done in parallel.
Vaibhav, do you see any other different set of questions, something that we have not answered?
Yeah, let me just quickly go through that.
There is a question, but I don't know, it would be different for organizations. It says, what is the approximate cost of compliance and how to prioritize budget?
So yeah, yeah, Dr. Rai, you wanted to start?
No, I don't want to guess. It's a very wider question, and I don't want to give a wrong impression. And particularly why? Because I don't want to spoil either yours or Kritika's market there. Okay. So if I say some figure, it should not become a benchmark for both of you. So I won't say. It may take, depending upon the organization, it may take few lakhs. And if the organization is pan-India, pan-cities there, the entire cost may take few crores also. That is the only setting of the framework. Implementation will depend upon what the process, what the gap assessment tells us there, and how the data structure is there, how database is there, who access, how many employees are there. So equipment cost will be separate. So few lakhs to few crore, depending upon the size of the organization, spread out organization. That gives a full liberty to full protection to Vaibhav and Kritika to raise whatever they want to raise it.
And it is very, very important from the MSME angle with this question. Like when I began to maybe highlight the question, I mentioned that it depends on the organization, but we have so many MSMEs and they also need to, comply with the laws. First thing that will come to their mind is that how much will it take? So they also need to understand they're part of the supply
Few lakh
chain
rupees.
and,
Few
yeah,
lakh rupees. For them, few lakh rupees.
okay.
Anyway,
Thank you.
I think both my
Thank you.
young colleagues are
Yeah.
not even interested in SMEs there.
Yeah.
Nothing like that, sir.
Mhm.
And yeah, it is very difficult to put a number, but with MSMEs, one thing that they should maybe also focus on is depending on the definition of the term startup, whether they fall into that category, can they rely on some of the exemptions, in the sense that can they apply to the government of India for consideration for deferred compliance, because there is a 5-year deferral that is contemplated in the Act. So I think there are certain mechanisms built in for these sorts of concerns. And maybe that's one way to look at how you want to design your long-term plan for compliance with the law.
But Kavitaji, I can give one point to you for you
Yes,
in the
please.
sense that one thing is there, whatever the expenses the SMEs or anybody does it for privacy compliance, that will get expense in the tax there. They will be taxed to that extent, tax exemption to not exemption, but tax will be less there. They can get it under the tax things. Number
Okay.
one. Number two, company like SMEs who have their very tight things on the limits from the cash credit limit or loan limit or things from the banks, they can always go to the bank and say, look, I have to comply with this, I have to do this, give me additional limit. Banks should be able to give it, because this is the statutory requirement, and it helps the banks also If there's a data leakage, if there is a heavy penalty there, ultimately the bank's money goes down the drain. So banks will be too cooperative to allow additional money to SMEs.
Thank you, sir. That's very, very helpful and very good for the participants who've been listening in, because that would be something that would be top of their mind, because they would like to certainly comply to the rules, but then this is a good assurance. And with that, I think we would like to, thank all our speakers for a wonderful webinar, which was very, very informative. In fact, the more we heard you, there were more questions that would be coming to the minds of people. And let me tell you, like we mentioned earlier, it's a journey. And next year also, in the first quarter, we plan to have another awareness session for all of you, because this is going to be something that people will keep having questions. So we'll come back to all of you for this DPDP webinar for sharing more information. I would like to thank Dr. Rai, Mr. Vaibhav Kaul and Kritika for all the information that you shared with us today and sharing your time. Thank you so much. Thank you, everyone.
Thank you.
Also tell them why all those frame, they are looking at the frame. Cutting down the frame and presenting somewhere else will fall under the Privacy Act. Means if cut down one frame and post it somewhere here and there, that will get attracted under the Privacy Act.
Okay. Important to know all this. Thank you so much. Thank you.
Thank you.
Till we
Thank
meet
you.
again. Thank you.
Thank you.
Everyone. Bye-bye.
Thank you.